So let's talk about undue influence and will contests. This concept comes up if a party is looking to challenge or contest a will after, let's say, their parent dies and they make an accusation that somebody else came in and essentially forced their hand to change their wishes in a way that wasn't really consistent with what they wanted. So you may have an individual who, took over the planning of the will and drove their mother into a law office and paid for the will and held on to that. And these are what we call badges of undue influence, things that could, lead to a presumption that the will they signed wasn't really of their own free will and therefore shouldn't be honored in court. So when we prepare estate plans, we try to be as separated as possible. It's good practice to only deal with the testator who's signing the will, the grantor who's signing the trust, without their loved one's involvement. So even if there's good intentions, it may appear like someone who's pushing this is really violating their responsibilities, and it could call into question the effectiveness of the plan altogether. So we really want to have that separation, that attorney-client relationship, strictly with the person who's planning and not their loved ones, no matter how well-intentioned they might be. And incidentally, in Florida, a no contest clause where you can write into a will that says if anyone challenges this, they don't get anything, isn't enforceable. It's against public policy here. So it's not a situation where you can just write that in and hope that's going to save things. So if you have any questions about estate planning or undue influence or a will contest, feel free to give us a call and we'll see if we can help out.